Hi, I'm Bill Crystal. Welcome back to Conversations. I'm very pleased to be joined again by Ryan Goodman, distinguished law professor at NYU, former special counsel at the Defense Department, co-editor of Just Security, really one of our leading commentators on many aspects of constitutional law and national security law. But in this case, in the last few years, really a leading and really thoughtful commentator on the various issues raised by the Trump presidency and I guess the Trump post-presidency. And 6 weeks ago, we discussed the documents at Mar-a-Lago, and I think that conversation for now stands up well. And in that conversation, I think you said, well, there'll be more indictments coming, and that even though the documents case will have its own zigs and zags, January 6th is maybe a different level of complexity, and I think that's may turn out to be the case. So we're going to talk about January 6th. We're having, just for the record, we're having this conversation on Thursday, August 3rd. Donald Trump was indicted 2 days ago for January 6th. He's about to, just after we finish, he'll be showing up in court in D.C., I suppose, to present himself, whatever the legal term is for that. But anyway, Ryan, thanks for joining me again.
It's a pleasure to be here with you and to have a conversation. So
you've been following this and contributing so much to the debate and discussion and explanation, really, of what's happening legally. And I really recommend your Twitter feed, which then links to so many other much more elaborate, obviously, discussions of the case and the charges and the law, the underlying law and so forth. But let me step back and just say, someone I was talking to last night, I was saying how much good work Jack Smith seems to have done and commentary so interested. And she said to me, well, but does it matter? I mean, is Trump just going to skate again? Doesn't he? He just skates on everything. What's the answer? Is this ultimately much ado about nothing in a sense, or not nothing, but much ado that's not going to lead to something, or is this, or not?
Sure thing. That's a great question. So I do think at some level we're already at the doorstep of accountabilities, the way I've actually thought about it, in the sense that here we are at a place that people even thought this would not be possible, that he has now been indicted as a former president, and was Garland really up for this, and the like. But in terms of this now coming through with meaningful accountability, I think there are two ways in which it could easily go down, and that there's a full trial and a conviction. And the first way is he does not win the White House. If he does not win the White House, I think he's going to be convicted in the D.C. court. And I think that conviction for the January 6, 2020 election interference is going to land him with a criminal sentence of imprisonment. It would be most likely. I don't know how he gets out of that. And I think that's a very real possibility. So much so that when the Bragg New York DA's case landed, there was a split of opinion, and some people were saying it's a strong case, it's a weak case, it's an unfair case, it's selective prosecution. The issue here is, can he actually outrun justice? Can he get into the White House? And that's his best prospect of evading true accountability. And then I do think there's another good likelihood that this particular case does come to trial and reaches a verdict before the 2024 election. A few things have to kind of cut in the right direction, but there are reasons as to why I think this trial can do that, and that this is not a normal trial in the sense that the Justice Department is poised to have it go forward in a speedy basis because of the public interest and importance of it for the public to do so.
Oh, that's really a wonderful way to frame it, I think. And I want to come back to the strength of the case, which is obviously important. But let's get right to, though, in a way, to the maybe what's more, I suspect, to the front of people's minds, which is, well, but can't you just delay? And will there really be a trial before the election? And maybe it'd be good if he were accountable even after he were defeated, if he is. But of course, if he's not defeated, he can pretty much end it all, presumably at the federal level. So how does it play out? Give me just sort of a sense of why are you reasonably, why do you think this could go faster than a lot of people might have thought, given the complexity of the charges? And we all know that these cases can be delayed when defendants want them to, and so forth.
Great. And I'm also happy to talk about how I think if he does win the White House, the mechanisms he could use to get rid of both federal and state prosecutions. Yeah, so I think that there are a couple factors that are different here. First, is Jack Smith's demonstrated interest in moving these cases along expeditiously, and he has said so explicitly. And I assume he will do something in the January 6th case that he's done in the classified documents case, which is to very much front load a lot of the information that prosecutors are supposed to turn over to defendants, but front load it in the sense that give it all to them now. That he's basically done that with a document dump in the classified documents case, including documents that there's only an obligation on the prosecutors to turn that over to the defendant on the first day of trial. So it's a strong signal to the judge, for example, that we are ready to go, and this is unusual in its speed that it can go, and giving the defendant better than normal due process protections. So it's not a trade-off in that sense. So I think that's one factor. Second factor is we're in D.C., and the D.C. District Court and Court of Appeals has heard and decided upon a number of the constitutional questions that would otherwise potentially pop up as threshold matters, and they are clearly in favor of the prosecution. So if we're talking about attorney-client privilege as it applies in private or as it applies to the White House and the president being decided in a criminal context, if we're talking about evidence and executive privilege being decided in a criminal context in this particular case with multiple defendants and their evidence, and with booster rockets of U.S. v. Nixon, which was about a criminal trial and the interests of justice in that sense, which is even greater than, I would say, the interests when we were just doing it in a criminal investigation. So some of the legal issues, I think, are already kind of pre-baked in. And those are other reasons as to why this could go in an expeditious manner. And we know the judge already, and she seems to be a kind of a judge that can easily run a fast courtroom or even at normal speed. So I think that there are other signals that this could go, let's say, in something like March of next year. Another signal is that the Manhattan District Attorney Bragg has sent a pretty explicit, implicit message in a recent interview that he'd be willing to move his date of his trial in the interest of justice, the interest of justice being that the January 6th case is much more important than his. And that also gives us a sense that from a prosecutorial perspective, he's thinking that's the space in the calendar that would be potentially helpful to open up.
So you think it's actually, I was going to ask you, well, what does expeditious mean? One man's expeditiousness is another's. It's 4 years. That'll really be expeditious. Some of your law professor colleagues say sometimes, complicated case like this. But you actually think that Smith at least has in mind, he's structured in a way to let it move very fast. And if the judge and the law is clear enough that the judge can go ahead and move it pretty fast, and whatever appeals Trump might, pretrial appeals Trump might try to take, don't necessarily slow it down much. That's basically your view?
That's my view, but these are views based on probabilities and projections, and I'll be looking for things like Jack Smith's stipulation of how long he thinks the trial should last. That's a big one as well.
Yeah, so talk about that. What should people like us who are less versed in this look for the next days, weeks, month or two, or three, in terms of, what would be the signal that this thing, this really is moving to a early 2024 trial or not happening?
I think two pieces will be what date the judge sets for the trial, which should happen soon, within a few days. We should actually know that.
So yes. The judge will set at least a tentative trial date.
A tentative date. It's like a date that could be moved based on conditions changing.
It's a real
date.
Yeah.
Yeah. It's a good.
And what would you think? That could be pretty soon. You think?
Yes, I think there's nothing wrong with judges. Nothing wrong. It's actually normal for judges to communicate with each other. So she could communicate with the Manhattan judge, and then I think she could set it up for March. And it also might depend on the other data point, which is, does Jack Smith follow through with what I'm describing, which is within the coming days announce that he's handing over all sorts of information and discovery to Trump. That would be another strong indication that we'll have I'd say within the next few days, maybe a week. And then a third factor, which has a lot of different dimensions to it, is what's going to happen to the identifiable but unnamed co-conspirators. And there's a ton of pressure on them right now. And now that there's an indictment that names them as a co-conspirator and shows the evidence of their criminal wrongdoing according to the Justice Department, if they flip within the next few days, I think that would be very important to understanding just how strong the case is and how much it'll move forward, and also move forward in a way in which they're not going to be multiple co-defendants potentially. And does the Justice Department get to keep Trump as the singular defendant in this case is also very important.
Yeah, so that's people I've talked to from prosecution world say that have been struck by the co-conspirators and the question of what their fate is. And so just explain that a little more. So what's exactly is the pressure on them to flip? Why can't they just sit there? They're not indicted. Well, they may be indicted, but I guess do they flip before they're indicted or after they're indicted? And two, how do you avoid the complexity of then multiple defendants at one trial, which I guess does tend to slow things down, doesn't it?
Yes, it does. And I do wonder if it seems as though the reason that they, just to answer your last question first, I do think that there's a good chance that Jack Smith decided to just indict Trump alone is that they are planning on and hoping for just a trial that's only got him as a defendant. And maybe they were also trying to see who the judge was. So with this particular judge, maybe it's not as concerning to them to have multiple defendants. Then the next question is what's going to happen to this co-conspirator? Or what has happened to the co-conspirators? Recently, the lawyer for John Eastman was asked by Aaron Burnett last night on CNN whether or not he expects his client to be indicted or the things like that. And he says, has been indicted. He says, no, he hasn't. The answer is, you don't know. Maybe he has, and it is under seal.
Is that right?
That absolutely. So those co-conspirators could be indicted co-conspirators. And maybe that's why, at least for some of them, the indictment doesn't mention whether or not they are indicted or unindicted. Because if they mention it for some, maybe they maybe have to mention it for the others, or by inference of absence, we would then get to an inkling that some of them have already been indicted. So that scenario one, some of them have already been indicted. Scenario two, they have not been indicted, but this is now the time in which the Justice Department will say, here's the indictment. We will indict you. If you do not, this is your moment. And here's a separate draft indictment. This one's just for you. So you can see what we've got. And you can see the charges. Jeff Clark, he's going to get, I think, an independent charge. False statements. You were trying to have the government make a false statement about that the Justice Department had already found significant election fraud. That's yours, plus some of the other stuff. And then that's the time for them to potentially flip. They could also flip post an indictment. The other part of this is, speaking to former prosecutors as well, I read the indictment the following way, and I know a number of other seasoned people do too, which is if you read the current indictment, there are a number of criminal allegations against those co-conspirators that do not necessarily connect back up with Trump directly. So much so that you can even imagine that what happened here is that at one point this document did include other co-defendants as indicted because it reads that way. There's stuff with Giuliani, for example, to make this concrete, where he is communicating with Cheesebro on the idea that they are very much deliberately planning to have these folks enter these false certifications of that they're the electors that are not contingent on litigation. And the two of them know, even if we lose in litigation, we're still using this for January 6th. But that doesn't directly tie it to Trump, but it's golden evidence against the two of them for charging them.
And how does it work when someone flips? So if you're, I don't know, John Eastman or anyone, and you're sitting there and either you realize now or someone approaches you and explains to you how dire your situation is, would we know if someone has flipped? Would that person make a public statement? Would we just come out at the trial? What's the story?
We would not necessarily know they flipped and would have to read the tea leaves / indicators. So by way of example, two of the strongest indicators that Mark Meadows has flipped and is cooperating are, one, he is not named as a co-conspirator. And in fact, he comes out smelling kind of like a little bit like a rose in the indictment. So that sounds like he's on their side as a government witness. And the reason I say that is because if you look at the January 6th committee report and the like, and I've looked at, I think all pieces of evidence that are publicly available, he has as much criminal liability as Rudy Giuliani, hands down. So the idea that he's not a co-conspirator, that's a strong sign. And then the second is the reporting by the New York Times and CNN. New York Times, CNN in May, and the New York Times in June, that quote unquote for months, FOR, the Trump team has been out of contact with Meadows and does not know what he is doing with respect to the investigation. And we know on top of that he has testified before the grand jury on, according to ABC News, on both the Mar-a-Lago case and January 6th. Okay, why is he not communicating with him? If he's taking the fifth in those grand jury appearances, then he surely would be telling the Trump people that to keep them on his side. And the indictment has a little bit of, those are the two main ones, but there's some other indications that Mark Meadows has flipped. For example, there's a communication directly between Meadows and Trump mentioned in the indictment, in quotation, so it's a direct quote, where Meadows is in Georgia, I think in Cobb County, and he tells Trump that the election officials there are carrying out their task in an exemplary fashion. Sounds like that's coming straight out of Meadows, and or they would not say that if they didn't have Meadows' testimony on that. So Meadows, I think, is flipped. And then it might be difficult with these other people, whether or not they'd ever be doing it publicly, but it also maybe the special counsel of the Department of Justice could release, as the Mueller team did, the plea agreement with the entire statement of what that person is owning up to. So, yeah, and we can also discuss one other piece of this that might be interesting, because I don't want it to sound as it feel like it might be sounding in some respects very optimistic about how these things might go down in terms of the interest of justice and getting a trial and accountability. Meadows, to me, actually also poses a little bit of a difficult case. I'm worried that he did not own up to his wrongdoing and does not have a plea agreement in which he has said, yes, I committed these crimes with the president, or engaged in these illegal acts with the president, or illicit or illegitimate acts with the president. It doesn't read that way. And if that's the deal that Jack Smith struck in order to get Meadows on side, I do not know how strong of a witness he will be, because that's not credible. And Trump will say, well, if Mark Meadows is saying he's an innocent person here in the witness stand, the Trump's lawyers would say, well, my clients did the same thing he did. So he's just as innocent.
But it sounds like you think that as the case moves forward, these co-conspirators are important. I mean, that they're potential witnesses against Trump. They're on the hook here. There will be a lot of pressure on them, I suppose. I mean, if you're John Eastman now and you're just talking to your lawyer or to your best friend, I mean, what do you think?
Absolutely. I think it's similar to the classified documents case. The amounts of pressure on a person like Giuliani, Eastman, Clark, Cheesebro is enormous, that in a normal case, I think those people would flip. Their defense counsel would say, you need to strike a deal here, and you need to be the first one in that door to strike a deal before the others do. And this as well, very much so in the classified documents case. And the only reason that I think they wouldn't do that is because the principal defendant in the case might be the next president who could pardon him, or somebody else who comes into the office who would pardon him or shut down the Justice Department's trial/investigation at that point.
Yeah, Trump's openness about his willingness and eagerness, you might say, to pardon everyone, basically, who's been involved one way or the other in January 6th. In that respect,
yes.
Helps him. It helps him a lot, right? I mean, and the past experience that people got pardoned if they stayed on side.
100%. Yes. Yeah, it's a rational calculation that they can include that as a factor.
But it is different from a normal case in that respect. I mean, whenever you think of mob bosses have other ways of putting pressure on subordinates not to flip, like they could be found in the in the Hudson River or something, but they can't literally pardon them, right? So it is. So let's talk about, let me just for a minute on what could go wrong, so to speak, in this scenario of people flipping and a pretty quick trial and a Jack Smith moving with great dispatch and having it already teed up, and a judge who wants to get to the trial. I guess I mean, how much ability does Trump have and the Trump legal team just to throw up a million different arguments? It's First Amendment, and he really believed this. He told this person that he did think the election was stolen. How come this is all illegitimate? And does that stuff just get dismissed very quickly, or could it really get tangled up in complicated appeals, or does that stuff not even get appealed before the trial? I guess that's one thing I'm a little fuzzy on personally. And then what else could go wrong?
So a lot of those questions, I think, could actually be handled in pretrial motions, like what are defenses they can and cannot raise, for example. And but they wouldn't appeal it. It would be maybe appealed after trial, so we'll still get a verdict. The ones that I would be thinking about are if Trump can claim anything that's in the realm of some kind of constitutional immunity or the like, and that's a pretrial claim that the court does not even have jurisdiction, so it would be prejudicial to him as a defendant for the court to even have the trial. You can't remedy that after a trial. You have to remedy it beforehand. So that's potentially kind of one area which there's some discussion about where that would go, but we can already tell from the Department of Justice's filings in civil cases that they've already fully briefed themselves in the courts and what their position is on that.
And so you don't think the defense has a huge opportunity to really bollocks this up necessarily, just by kind of legal motions and the normal, well.
I think a lot of that depends on the judge and the management by the judge. Just like in Mar-a-Lago, they were doing things that to me are somewhat, unforeseeable, like the defense counsel not even filling out his forms for a security clearance. But if it was a judge, which I think might happen in DC, who said, look, if you don't fill out your form by the end of tomorrow, you're off the case. It's prejudicial against you, and we're moving forward. Like, I'm not going to tolerate that. And we've seen many more judges now across the country not tolerate Trump's shenanigans of using these kinds of devices within the legal system to try to slow things down. So I think that would be another thing to look for in terms of what is the judge's disposition toward those kinds of shenanigans.
You mentioned that, well, this shouldn't be in court at all. And I guess a slightly different version of that is, well, it certainly shouldn't be a court of law during an election campaign. And you say March, and I think Super Tuesday and the Republican primaries. And that's not quite like the general election, but it's a real election. And how can he be expected to show up for such a trial and prepare for it? How can voters be expected to know what to make of it if they're voting one day after either, a strong prosecution witness or a strong defense witness? Shouldn't the whole thing be put off? I assume he'll make some version of that argument.
I think he will make a version of that argument, and I might be in a different place on this than many other people. I think many people would disagree, which is, I think that judges could come out on different ways on that. So he did make that argument before Judge Cannon in Florida, and I could imagine that just at a random selection of judges on the bench, some would say that is a legitimate argument. I will take it into account. And we need to think about the calendaring of this vis-a-vis this national election. Also, if it gets too close to the election, maybe it's a time for us to kick it over to post the election. And I would imagine there's another set of judges who would think, no way, this is not a consideration at all. Judge Cannon said that she wasn't taking it into account. In the oral argument, even said to Trump's lawyers, move on, give me a different argument, because that argument's not relevant here, because I don't quite understand the biases that you're thinking are going to kick in with the jurors pre versus after an election. But in her written order, she just basically says, I'm not deciding that now. So if there are delays that are expected and unexpected post her date in May, and then it starts to kick it and then kick it again. And she says, oh, no, look, it kicked it just a few weeks. But then in those next few weeks, my calendar is totally booked. So now we're thinking about August or September. Then she might revisit that. And I could see other judges coming out similarly with actually saying this is a legitimate factor for me to consider. But I do think there are other ones who would say, kind of like the Justice Department, which is saying it, I think, implicitly, not explicitly, exactly, there's a national election, this is a crucial issue, and that voters should know this information before they vote, preferably as soon as possible, before kind of a Super Tuesday-ish thing, preferably before the Republican convention, and then preferably before the general election. You could imagine that would be a different mindset. But I don't think there's not a playbook for this, or a guidebook, or something one can teach in a law school classroom that says this is the right answer. I don't think.
I mean, we've heard about these Justice Department guidelines that you shouldn't bring a political case.
Yes.
What is that? 60 days before an election, I think. But this case has been brought now, so it's not That's
Exactly. Yeah, I don't think it applies because it is about like taking an overt action, and that might be something like an indictment, or even not even an indictment, but maybe even bringing evidence before a grand jury because it can so easily leak within a 60-day period. But that's like an initial, like as you're suggesting, an initial overt action that announces something suddenly that nobody else is aware of. That as a tool in the hands of a Justice Department with biases or ill motive could be very dangerous.
I mean, it seems to me, as a total layman here, that the credibility or the weight of the argument that we shouldn't do this in the middle of an election campaign goes up as you approach the general election as opposed to the primaries and sort of after the Republican convention. I don't know if that should be a get out of jail free card or a get out of delay until after the election card. But you could sort of see people saying, well, he's the nominee of one of our two major parties here. I mean, he's being prosecuted by the Justice Department, albeit it's a special counsel, it's independent and all that. That's in the administration of the opposite party and maybe likely the opposite candidate. That just seems untenable. I mean, I guess people might. I mean, a judge in good faith could think that was not simply an expedient argument for Trump, right? There's some weight to that argument, I think.
Yes, I'm in agreement with you on that.
Yeah.
Yeah.
So that would suggest, I mean, not that he or she might still decide that it's outweighed by the public interest in getting this thing done, and the other way,
yes.
But and giving guidance in a way to the voters, but or just having a fast trial, which is itself something that we have.
Yes.
The system does have a certain belief in, right? I mean,
absolutely. And the other one that's also kind of interesting is just the interregnum period between an election and January 20th. So if they think that the trial could take place within a month, I could imagine a judge like starting to really focus in on that question would say, well, that's an untenable position because if he loses, it's okay in a sense, but if he wins, now what? So, and therefore we need to decide this beforehand. But it's complicated, and that, just as you say, I think good faith, reasonable determinations or ways to look at it from either side.
But you think Smith really has tried to build it as much as he can, consistent with legal rights and propriety and so forth, for a fast, and he said that himself, I think, a speedy trial, right? And so, which is within his, not just his prerogative, but in some sense his obligation now under the law. I mean, you're supposed to give defendants a speedy trial.
Yeah, supposed to give it to defendants, and there is a part of the law that is explicit about the public interest in a speedy trial as well. So for the public to know, yeah.
And just one more thing on this, and then I'll come back to a couple other aspects. On the trial itself, I guess it'll look like a normal trial. I mean, it seems it seems like such an extraordinary thing. He'll be sitting there with his lawyers, and the prosecution will be there, and they'll be calling witnesses and having cross-examination, and just like other trials that we've either seen on TV, not in the case of federal trials, but seen transcripts of or read accounts of.
Yes, and somebody recently asked me, and therefore in the witness box, do you think there's going to be his own former vice president, and it will be that kind of a spectacle? And it said a normal trial, but spectacular, and it's a spectacle in that sense, with one wild card, I guess. And the one wild card is, having spoken to experts on this, so I don't know this firsthand in my own research, the federal rules of criminal procedure do not provide for a public video broadcasting of a trial, but the Chief Justice of the Supreme Court apparently can overrule that. So I imagine that there's going to be a lot of interest in saying that this is a special case. It is not a normal case, and that the public has every reason to know. And Trump's lawyers have actually suggested that as well. I think they did that. Maybe it was more in the Mar-a-Lago case first, but it wouldn't be just to that. Yeah, I think it was in that case because he hadn't been indicted yet for January 6th. But they were saying, oh, we want a public trial. I first thought that there was just blowing smoke because they know that the federal rules of criminal procedure don't allow for it. But if they want to call for it and the Justice Department says, we'll agree, yeah, we consent, then who's left to oppose it really, except maybe the judge in the courtroom. But I think that there would be strong reason to have this be aired publicly. It's one of the most important historical trials for the entire, for the country's history.
And the normal reasons, which I never really read about, studied, but which I could guess, I think, for discouraging televising in real time trials. People could huge hostility to some defendant if there's very adverse testimony and even violence and all kinds of other things. I mean, none of that really. Violence obviously does hold. I mean, it doesn't hold in this case in the sense that 99.9% of the people are paying attention anyway. So it's not as if someone's going to be unjustly. Someone's going to be unjustly pilloried. Someone you've never heard of, is suddenly on trial, and as someone's describing some terrible thing, and the whole country decides this person's horrible, and you don't want people to just decide that based on 2 hours of testimony on Wednesday afternoon before the rebuttal testimony on Thursday. But this wouldn't be that. It feels like that kind of consideration wouldn't obtain here. Right?
I think that's right. And we'll have reporters in the courtroom, but so it's a public trial. It's just that it's not video. So you have to think about what is the real delta between those two things. Yeah.
So you mentioned Vice President Pence. I was on my list of things it's pretty. He seems to have testified before the grand jury and is in effect quoted, or not quite directly quoted, but as it were quoted I believe in the indictment. Is that right? And presumably there's no reason not to testify. I mean, no excuse or no ability not to testify if called at a trial. Is that right?
That's right. And I did think that was one of the most important variables for the prosecution is what would Pence do? Because I don't think he's as a legal matter, the victim, but if he, as the target of the Pence pressure campaign, was not going to be a good witness, that would be a very bad charge to bring. So I think it's very likely that they know exactly what they can count on. That's why they, in fact, have him in the grand jury to lock in his testimony one way or the other. It sure looks like he is fully cooperating and will speak his truth, and that it will reflect and track his book. And his book, I think, is just remarkable as evidence, incriminating evidence against the president, and goes far beyond what one needs to have in a book for it to sell, copy, and be read by people with interest. So he's I think, very important witness in all of this. And I think will come across as just a highly credible witness. And even in the last 24 hours, he's saying things that are super important if you think about like what's in the details, which is he is saying President Trump, and I forget his words for like wackadoodle lawyers, right. Were telling me. I think that was
his term, wackadoodle, the technical term.
Oh, was it? Okay, right.
Wackadoodle, and his wackadoodle lawyers.
Yeah. Were telling me to outright reject the electors. And for those who track this very closely, there were 3 things they were telling him, potentially, and it sounds like all 3, but that is the key. That's the kryptonite. That one is so bad. And it's also bad because I can explain where this comes from, but John Eastman is now saying that he never told Trump that was a legal option. So the fact that Pence is, I think he's super smart, and I think he has a super smart legal acumen. So when he says that, it's very important to the case.
It was a little stronger almost than you say. I think he explicitly, the questioner said, well, did Trump ask you to pause the process? Or at least that's what the Trump people are saying now. And it was just a pause. I think Trump said that recently. It's just a pause. I just wanted him to give the states more time to work on this. And Pence, I said, no, I think explicitly said that is not true. He wanted me to throw out the votes, and not to pause the count, but to what's the word I'm looking for? Discredit, to reject the electoral votes from the states in question, so that there would not be a majority in the Electoral College, so that it would go to the House. And then Pence says that would be just chaotic and terrible. So it does seem like he's went out of his way to rebut the milder version of what Trump claimed he was asking Pence to do in this interview just a day or two ago. I was struck by that too. Yeah.
Yes.
So in a trial, so Pence would testify, and they'd all. I mean, how does it work in trial? I should know this. People get called as witnesses by the prosecution. You don't have any you don't have the chance to say, "I'm sorry, I just kind of prefer not to show up," or "I'm very busy this week," or something. You testify, right? I mean, you can take the Fifth Amendment, but
exactly. And in this case, the 2 things I think are true are, one is that the prosecution knows what these particular witnesses are going to say. And they have great visibility in the sense that they've probably, triangulated this from so many different angles, because it's not it's not a case in which there's like a single witness. There are multiple witnesses in these very important meetings and activities across these months. So very difficult for people to not show up and tell their truths unless they also have convenient lapses in memory. But convenient lapses in memory are also potentially false statements on that witness stand. So I think that's also, and I think that there's a very good chance that the special counsel is sending a signal by his recent superseding indictment, including false statements. So
interesting.
it's a, yeah.
This is the superseding indictment in the Mar-a-Lago documents case.
Yeah.
That you're not going to get away with false statements, either to FBI agents or in court, obviously.
That's right. That's right. Yeah. And Mueller did something very similar. So let me ask the question in this order then. And privilege claims, I think you mentioned this very quickly earlier, but the courts have sort of already decided in a lot of analogous cases, I guess, or relevant, kind of cases that are cousins to this case, that you don't have much in the way of executive privilege or attorney-client privilege that would stop the White House counsel from testifying, or Bill Barr, or from testifying, or maybe not Barr, but the people who succeeded Barr and who stopped Rosen from his attempted DOJ coup and so forth. I mean, those people one would expect to see on the stand? I'd say 100%, in the sense that, just by way of example, there's a DC Court of Appeals decision on I think it was a deputy White House counsel of an incumbent president. I think it was Clinton at the time, an incumbent president. And they said for a criminal setting, you have to testify. And part of it is because as a government attorney, if anything, there's an obligation for you to come forward with information about evidence of crimes. So that's what I mean. Like, it is stacked very favorably for the prosecutors, and that you have to imagine. We've seen the reporting on this, but all these decisions have been secret. You have to imagine that the Court of Appeals of the D.C. Circuit has already decided for a bunch of these high-level White House officials that they do not have executive privilege, or a version of it of attorney-client privilege in the executive branch on this particular matter.
That's why they've already testified at the grand jury, presumably,
yes.
Right? Yeah. So that was sort of resolved at that level, you might say. Yeah, that's interesting. So the people who we saw just snippets of, in most cases, in the January 6th committee hearings, little video of Pat Cipollone or whatever, the Philbin, the deputy counsel and stuff. Mm-hmm. A few of them testified, but not that many in live, so to speak. They'll be there. I mean, they'll be on the stand, and it'll be a more expansive testimony. Presumably, they can get cross-examined too, of course. So it sounds to me like that would be a pretty dramatic trial, right? Former Vice President. I guess I'm saying this. It's like just stupid things. It's an obvious thing to say. So why am I surprised about this? Of course, it's a historic trial. But when you really think about it concretely, what that looks like, and today's the former Vice President of the United States, and tomorrow is the former White House counsel, and then I guess I mean.
Yes, I think it's super dramatic. The only thing that could make it more dramatic is if some of the Trump family were witnesses or something like that. Yeah, that would be right. But it's super dramatic. Those people will testify. It's not going to be so heavily redundant with the January 6th committee, in part because of how you described it in the cross-examination and the like. I also think some of the January 6th committee depositions, now that we see them, were not as what's the best way of putting this? Not as exacting as I would have liked. And I think we'll have the best of the best from the Justice Department in all likelihood doing these kinds of cross-examinations. So getting at some of the very specific issues very concretely. And many people might not have noticed this, but when even Greg Jacob testified, there were moments in which it seemed as though there was a very clear...
Pence's counsel, Vice President Pence's counsel.
Yeah, who's, I think, just incredibly compelling witness. Somebody who seems just like a really upstanding lawyer, and is also driven by faith and just extraordinary. And but it seemed as though they had very much agreed that there were certain guardrails, that he was not going to talk about things that might be a direct conversation between like Pence and the president. In terms of the January 6th committee, so there are guardrails on executive privilege. Same thing with Trump's White House counsel, Pat Cipollone. Same thing with Trump's deputy White House counsel, Pat Filburn. And we can tell from the indictment, they got that testimony. There's like one of the most important lines in the indictment is that deputy White House counsel, Pat Filburn, says to Trump in December, "You have no option left to stay in power past January 20th. And that's the quote is something like "no option." I assume he is the lawyer, so what he's actually saying is no legal option. Right. And that's compelling. That's compelling.
So you think the facts end up being, it sounds to me, pretty compelling, actually, in this case. And I guess then Trump ends up trying to argue a lot of the laws are too vague, or they're, whatever defendants always argue, and sometimes they can be correct, obviously, or inapplicable to this case, or this was meant for, just defrauding the federal government by stealing Social Security checks. It wasn't meant for defrauding, the public and the voting rights, the law that was originally a voting rights, civil rights law, really. That wasn't really meant for this kind of depriving voters, tens of millions of voters, of the legitimacy or the effect of their vote and so forth. In general, does any of these arguments strike you as likely to go anywhere? And how much does it matter? That is, I guess, do they get to make these arguments in the trial court and convince juries that the law is problematic? Or is that more for the judge? Is that more a matter of something the judge resolves ahead of time?
Right. Some of these questions would be for the jury, some would be for the judge. I don't think these are going anywhere. I think it's such a formidable case. So I do know that there is some writing out there that suggests there are these problems in the law, but I would just say that, so let's just do the Civil Rights Act law that came out of the Civil War. It is definitely true that it was first intended for use of violence committed against Black Americans to stop them from voting by white supremacists like the KKK. Absolutely. But over 100 years ago, the Supreme Court has said that it also applies to criminal conspiracies to not count people's ballots. So it's like hand in glove here, in a certain sense, with the facts and what the Supreme Court has said and multiple times upheld that. And that if you just pick up the Justice Department's, I think the last year maybe was 2017, their manual on election crimes, it lists examples of crimes under 241. They include several schemes for election commissioners and the like to not count people's ballots properly. So that would apply to throwing out people's ballots or the electoral ballots from the 7 states. The other statute on fraud, the idea that it only applies to deprivation of victims of their monetary or tangible property, that's a different statute. And the Supreme Court over 100 years ago said for the statute that Jack Smith has charged, which is a criminal conspiracy to defraud the United States, it applies, as it says explicitly, yes, monetary and physical property, but also interference with governmental functions. Mueller charged the Russians with the same statute of interfering with the administration of U.S. elections in the 2016 election. Nobody batted an eye about that. So is it possible that somebody could come up with a constitutional argument as to sure, I guess so they could overturn 100 years of Supreme Court precedent, but that's after, let's put this way, that is after the conviction. So I don't think that works. The First Amendment one, I think, is a total, not even a red herring and non-starter. It's just not this case. Jack Smith very deliberately indicted in a way in which it is not dependent at all, not even not dependent. It's not alleging incitement from the Ellipse riot, from the Ellipse speech, excuse me. He's not alleging anything that really hits a First Amendment issue. If he did, I would be the first to either say, oh, yes, let's roll up our sleeves and discuss where the First Amendment is or isn't, where the lines are drawn. So when people say it's not a First Amendment issue, it's not because they're saying, oh, the lines are drawn in such a way that the First Amendment does not extend as far based on some jurisprudence. No, it's just, this is not a First Amendment issue. It's like, I think Larry Chavez may be the first person to say this. Somebody goes into a bank and says, stick them up, give me your money. And the defendant says, oh, no, that was my First Amendment right. It's that kind of a case. This is not a First Amendment case. And then there's the advice of counsel. I think that, to me, has always been potentially Trump's strongest defense. And when I saw the co-conspirators, I thought, that is the strongest argument to the strongest defense. It is very difficult to claim that you relied on your advice of counsel if your counsel were co-conspirators in the criminal scheme. plus a bunch of other reasons that one won't work. But to me, maybe that's the best one they've got. And I'll just also say, I suppose, because this one's also important, and I think this is a good faith argument that people have out there. They think that, it's not disingenuous, they think that the prosecution has to prove that Trump believed he lost the election, that he knew he lost the election. I do not think that's the case for so many basically all of the counts. There are certainly versions of the case that could succeed if they prove that beyond a reasonable doubt, but they do not need it. Just a couple of very quick examples. He can think he won the election. He could even have won the election, and it doesn't give him any legal right to threaten the Secretary of State of Georgia with criminal penalties and threaten him with physical violence from mob violence, which is what Brad Raffensperger testified before Congress, is what he thought the two threats were in that phone call. So he cannot, even if he thought he won, and he won, he cannot pressure the Justice Department to send out a clear false statement that the Justice Department has found significant fraud when they have just told him they have not found any significant fraud. It goes on and on and on. There's so many of these. So I don't think that one is going to work either. And in fact, I could even imagine that Jack Smith is happy to think that the Trump lawyers who are now on the airwaves believe that that is their defense, because it is just not a defense to these charges.
Yeah, even if you think a bank has unjustly taken some of your money from your checking account, and even if you're right that it has, you don't get to go into the bank and hold it up, right? I mean, so that's, I think, what the First Amendment thinks, and even if you have one of your co-conspirators is a lawyer who's giving you some fake arguments about why you have that right, especially if you can show that you didn't really believe those arguments. Yeah, I think it's it's interesting, but I do feel like people say, well, no president's been charged under this complex of laws before. But I think the answer to that is, well, no president's ever done what Trump tries to do before. And each of the laws, correct me if I'm wrong, each of the statutes has plenty of case law behind it, right? I mean, lots of people have been, as you said earlier, have been convicted of depriving people of their right to vote, or their votes being counted appropriately. And lots of people have been convicted of defrauding the federal government, not just in a monetary way, but in a broader way, so to speak. Is that right? I think that's right. So in that respect, they're on good legal ground. Good legal ground. It's just Trump happens to be president, and in previous cases, the conspirators were, or the actors were less prominent.
Absolutely, and yes, everything you just said. There are dozens and dozens of cases, even to the point that if there were some way in which this gets to the Supreme Court and some constitutional or statutory interpretation type argument, the Supreme Court's going to be looking down the barrel of, oh my God, are we going to overturn the last 100 years of how this statute has been used and deprive the Justice Department of its ability to use the statute in the future because we somehow favored Trump in this case? That's rock solid. And I think the Justice Department was very deliberate, and I think it's probably Garland and Smith. They wanted to take statutes off the shelf that had been used in like cases and to say, we're treating likes alike. What would be special here is if we didn't prosecute him. It's very similar to the Espionage Act case. There's so many Espionage Act cases that are with a lot less egregious facts than
this is the documents you're talking about.
Yeah, exactly. And I think something very similar here. Yeah.
Yeah, no, I think that's an important point. I mean, it would be unjust to not treat Trump in the same way others who tried to do similar things at lower levels, as it were, with less scope, have tried to do these things. So it's the opposite. I mean, you could argue of the politicization of the Justice Department, or the weaponization of the Justice Department. It really is applying the law impartially, right? Or at least that's what Smith will certainly, and the Justice Department will argue.
Absolutely. And based on the most recent statistics of early July of this year, well over 300 people have been charged for the obstruction of the congressional proceeding. And it's kind of like, so if all of them are being charged for it, why not him? And is it? And I also think there's another way of looking at it too. If you look at the co-conspirators on the indictment, they will be charged in a sense, or they'll flip. But I think they'll be charged. Otherwise, there's no way the Justice Department is going to turn a blind eye to the Justice Department's view of their criminality. Can we imagine a world in which those people are charged and Trump isn't? The rule of law should not tolerate such a situation. So I think it's that would be the politicization of the Justice Department.
Yeah, that's interesting. So just to maybe close on this point, you said we're at the beginning, we're sort of at the doorstep of accountability, which I think is a good formulation. It sounds to me like you think, though, that as we go through this case, especially perhaps with the co-conspirators and whether they flip or not, but just as we learn more, that if we get to trial and learn more there, that the case gets stronger and not weaker. So that is to say, people are looking at it, it feels to me like, and they say, oh, pretty impressive, 45 pages. But I don't know, is it really fully convinced? But of course, an indictment is just an indictment. I mean, it's not just an indictment, but it's not everything is in those 45 pages, right? I mean.
That's it. Yes, absolutely. I think I've seen the same kind of analyses, and it is a logical flaw for people to say, well, if he had this evidence, he would have presented it, etc. No, he's only, I think he's thinking like a prosecutor more than he's thinking about public messaging. So it's like, this is what I need to show in the indictment. I'm not showing all my cards to the defendant. I don't have to. And he could hold back on so much evidence. And by way of example, we know of two pieces of evidence that are rock solid that he does not reference in the indictment when he's talking about Trump's use of the Justice Department to try to get him to make false statements and send these letters to Georgia and elsewhere to try to overturn the popular votes in those states. Two things are, one, the White House counsel, Pat Cipollone, did testify in the congressional investigation that he called that letter a murder-suicide pact in front of the president in an Oval Office meeting. That's not in the indictment. That is explosive material. And especially for Americans who have not read, have not been tracking this so closely. If they read that in the indictment, they'd be, oh my God, Trump's own White House counsel is calling this a murder-suicide pact to the president as to why they can't send this thing. The second one is the Justice Department thinks at that meeting that Trump is going to fire the acting attorney general and replace him with Jeff Clark. They write a draft mass resignation letter that stipulates and says in it, over the past weeks, the acting attorney general has resisted the president's efforts to use the Justice Department to improper ends. That's strong evidence that they just have. You can see the document. Politico had it first, and you can Google it. It's not in the indictment. It's just a good indicator. And actually, Tom Joslin just wrote a piece for Just Security today, and he lists those two examples. That's where I'm getting them from. And Tom Joslin was a principal drafter of the January 6th committee report, so he's extraordinarily familiar, maybe more than almost anybody, with the record, and notices, these are not in the indictment. So just and he says this is, evidence of how much Jack Smith is holding back and can hold back. There's no reason to present it all here.
And so that all comes out at trial. So finally, I mean, what do you think about, you mentioned at the very, very beginning, you had a couple of thoughts about what Trump does if he wins or loses, but just, I guess, net, you think trial is more likely than not in 2024?
Yes, and I think it's this one. Also because I don't trust Judge Cannon to hold the trial before the election. Push comes to shove. So yeah, I think that this one does come before the election. And I do think that in a way, if I were Donald Trump, I would think one of my best shots is to win the White House. And that is a way to avoid these prosecutions. And if he gets in the White House, it's the pardon power. It's also that he is the chief executive of the Justice Department and he can just shut it down. You can just say, I've always said this was a hoax. We're shutting it down. Why would I keep this? And I said that before I ran. So that's my mandate. People voted for me to shut it down. And I think this is one other piece that people don't necessarily have their eye on the ball. I could imagine that the U.S. Supreme Court will side with the Office of Legal Counsel and say a sitting president cannot be subject to indictment, trial, or sentencing while they are president. And that applies even more so to state and local prosecutors who might be elected from a different party and the like. So if that's true as a federal level, it's maybe even more true for, let's say, Georgia and Manhattan. And that's why those cases might go away for 4 years. And if they go away for 4 years, they might go away forever in a certain sense.
Yeah, I think that's a good point. People seem to be a little too credulous about the thought that, well, the state, you can't use the pardon at the state level, but there are other reasons why, and it's not crazy to say that you can't have every local prosecutor prosecuting a sitting president of the United States. It'd just be insane, And yeah. How do you distinguish the good faith cases from the not so good faith cases and so forth? But what you're saying is even if Trump were convicted in June of 2024, it'd be on appeal, and Trump could order the Justice Department to, in effect, I don't know, do what exactly, yield to the appeal or not contest the appeal or something, and apart from pardoning himself and all that stuff too. But
Yes. Yes, I think that's one of the mechanisms he can pull, is that the Justice Department is going to withdraw its appeal or withdraw its response to the appeal, or whichever which way it cuts. And then the only question is, I think state or local but who knows? I mean, this is a real complex question, which is, let us imagine that he is convicted in Georgia and now it's on appeal, like a multi-year appeals. Then maybe the OLC opinion of the constitutionality of a current president being subject to, that might be very different, because it's like, oh, come on, like he's not in jail or in prison. It's just appeals. He can deal with appeals in a litigation, and that the sentence would just not take place within the 4 years while he's in office. This is like such radical set of facts, and because that's the world that we happen to be living in, so it's hard to even anticipate that.
So just in the short term, things that will happen, apart from an hour from now when Trump shows up at the courthouse, that we should be looking for. It sounds like what you're saying, we'll get some indication of how fast Jack Smith thinks he can move and intends to move, and maybe some indication of whether the co-conspirators have been or will be, well, whether they will flip or whether they've been indicted or will be indicted. Those are kind of things that could happen in the next weeks. I mean,
yes, next days or weeks, and that's what I'm personally looking for.
And then we'll also get a scheduling of the trial, at least tentatively, which would give some sense of what the judge thinks is at least a beginning place from which, of course, there'll be, we need more time to do this or that, but at least give some sense of what she thinks is sort of plausible or reasonable or what she's aiming for, right? Yes,
absolutely. At least it's something that's in the calendar that is meaningful.
And how long would such a trial be? Do you think?
I don't know. So in a certain sense, the Mar-a-Lago one, I think Jack Smith asked for 3 weeks he thought it would take. Here, it's hard to wrap one's head around because there are so many witnesses. I think that to me is what makes it, A, there's so many witnesses, and B, it's a multi-pronged conspiracy. That sounds like a long trial. That sounds like 3 months of a trial. I don't know.
You think, yeah. But they don't have to call of course, I mean, as long as one witness is, now if on defense, if defense challenges, I suppose, a certain witness, then they can call other witnesses to back up that witness and so forth. But if they have the White House counsel saying something, they don't have to have every single person who was in the meeting confirming that the White House counsel did say something or did hear Trump say something, I suppose.
I think that's a great point. And there's also another one that goes along with it, which is kind of dovetails with something else we were talking about earlier. There are certain witnesses that were there along the way for a large part of this. Mark Meadows in particular is in the most important meetings. He's running point on the false electors scheme, all sorts of things. So he can narrate so much of the prosecution's case.
Yeah, that will be interesting if and when we learn about Meadows. So much of this is going to be interesting. So we'll have to have another conversation as we learn more. But this, Ryan, has been extremely helpful for me, and I'm sure for our viewers and listeners, and just laying out kind of what to expect and what we're dealing with here. And it's a big moment, right? It really is a big moment, and it is a kind of beginning of accountability. Almost whatever, not whatever happens, but almost whatever happens in the actual next, I feel, 15 months. It's a big moment already just to have this. Don't you think, to have this indictment?
I definitely think so. I one of my greatest concerns is that we haven't seen this kind of accountability, just this step in the past with senior officials from who cares the party. And so this is such an important moment for the country. I think it could be a turning point for the country as a kind of a deterrent and a signal to others even in the future, like it will get this far. Nobody is beyond reach of the justice system when the crimes are this egregious.
Yeah, it's a good note to end on. Ryan Goodman, thank you for joining me today. It's really a terrific conversation.
Thank you. Really appreciate it.
And thank you all for joining us at Conversations.